Our next speakers are Michael Perlin and Heather Cucolo. Michael is an emeritus professor at New York Law School and a leading authority on mental disability and mental health law. I've known Michael for many years. He's a prodigious author and a very, very leading advocate and expert on these topics. Heather was one of his students many years ago, right? And now she is a very accomplished mental health and disability lawyer in her own right and is now teaching at New York Law School as well. Both Heather and Michael are members with me in what's called the International Society of for Therapeutic Jurisprudence. And we are working on ways to make the law more receptive to psychologically healthy outcomes in law and public policy and in legal disputes. So it is with real pleasure that I introduce them to talk about how to provide dignity for persons with autism in the criminal justice process. So Michael and Heather, welcome.
Thank you, David. It's always a pleasure to be here. I think in the last 13 years, I've missed one of these conferences only. And it's always just the first thing on my calendar every year. Heather and I are going to do kind of an A-B kind of back and forth format, which we hope will be okay. And if not, that's the way it goes. In the last 50 years, autism, or autism spectrum disorder, ASD, has gone from a very narrowly defined seemingly rare disorder of childhood to a very well-publicized, advocated, and researched lifelong condition, fairly common, very heterogeneous, results from altered brain development and neural reorganization, and it is especially under-recognized in some racial ethnic groups. There are serious cultural issues that are involved in the diagnosis of autism. Such persons very typically will have some deficits in social communication, nonverbal communication, maintaining social relationships, may have repetitive movements of language, repeating a phrase unusually times, and may develop or display behavioral rigidity. This is not going to be news for anybody in the room. And now it's Heather's turn. I can read fast when I have to.
So, as a result of, again, some of the deficits, and then when I say deficits, I think that that's a term that I'm not necessarily comfortable using. I think it's some of the distinctive behaviors that are seen as different, right, or seen as, quote, abnormal. The problem with this, of course, is in many scenarios, many communities, many situations, in particular when we enter into the criminal justice realm, the criminal justice system. And what we see is some of the studies, some of the scientific and psychological information and studies that pertain particularly to persons with autism seem to be more prevalent in how they are expressed within the criminal justice system. And what Michael and I focus on is the view of attorneys, the view of judges, the view of the courts, the view of the jurors in particular, which is a major part of our focus in this, and how the views of ordinary common sense, heuristics, contextuality, those areas where individuals say, well, I know exactly what autism looks like. You know, or I know that persons with autism are either fundamentally delayed or fundamentally developmentally disordered, or I know persons with autism are absolutely, they can function just like anyone else, right? There's been a lot of information, a lot of knowledge in autism, it particularly pertains to schools, etc. But the idea is this ordinary common sense really makes its way to the courtroom and the court system, and in particular, really flows into how these persons are being perceived and then thus adjudicated, right? And it isn't, of course, just the layperson, right? It isn't just the jury members, it's the attorneys themselves. And attorneys across the board, unfortunately, when Michael and I do our work and talk about mental illness, in particular developmental disability, and other various areas, attorneys are, unfortunately, not as knowledgeable as they need to be in order to combat these stereotypes, this ordinary common sense, etc. And if they don't utilize the particular centralized experts, if they don't utilize this extra needed, necessary knowledge with regard to various and different disorders, then what they're doing is an absolute disservice to the client. And they're doing a disservice to the client, and they're also potentially ethically violating their duties and their roles. And they are just continuing the humiliation, the lack of dignity that these individuals are having to confront from the beginning of the criminal justice system to, again, arrest, procedure, all the way through. And it's the attorneys, the defense attorneys in particular, they have to be the heroes. They have to be the ones that are willing to make sure that these stereotypes are not going to affect their clients. And what we've seen, unfortunately, is that's just not the case.
And building on that, I mean, one of the things we know is that jurors think they can tell if somebody is being remorseful. They can tell if somebody is being empathetic. Of course they can't. They have their own view of it. And this plays out especially in the worst of all cases, death penalty cases. The Supreme Court said in Atkins versus Virginia, which struck down the death penalty for people who are intellectually disabled, that the demeanor of such people may create an unwarranted impression of lack of remorse. In his concurring opinion in a case called Riggins versus Nevada about drugging certain patients with mental disabilities at their trial, Justice Kennedy said assessments of character and remorse may carry great weight and be determinative of whether the offender lives or dies. There's no reason to expect that jurors would respond any differently in any other kind of criminal trial. We look at all of this through the framework of therapeutic jurisprudence, which I've spoken about by myself and with other colleagues over the years here many times. Basically, it says the law can be therapeutic or anti-therapeutic, and what it does, we want to emphasize wellness. We want to emphasize the healing characteristics of the law without in any way diminishing due process. We want the law to bring around healing and wellness. So, how do we remediate this? We have looked at, and Heather's going to wind up, but give you three sort of different focuses that I think we need to look at to make this work.
So we have the notion that judges need to explain to juries that they can't rely on their false ordinary common sense, what I noted, about what remorse looks like or what an empathetic person looks like. The notions, again, this concept of ordinary common sense. Basically, of course, I see it that way, therefore that is the way it is. So we have to rely on the judges for that. And then in particular, the other component, of course, is expert witnesses. They have to be provided for the person at risk. And again, we know that they can't always necessarily find someone who's going to testify on behalf of that individual or be an advocate on behalf or assist the advocate. But that's the whole idea, is that making sure that attorneys reach out, that they find other individuals and experts who are going to be able to give them further education. And my time's up. Finally, greater care in selecting jurors.
For those of you who want to learn more about some of the work that Michael and Heather have been doing, they're also co-authors of this massive, how many volume treatise on mental health and disability law?
More than I can lift.
Yes, so it's a good, weightlifting kind of experience as well. But thank you very much.